All right, counsel, are you ready to proceed?
Yes, Your Honor.
Okay. Good morning. Today is May 16th, 2024. This is the time set for oral argument in our case number CV23-0051, Melissa Turner versus R. Bradford Turner. Out of respect for counsel and to avoid any embarrassment for anyone in attendance in the courtroom, please make sure your cell phone is on silent. Each side is allocated 20 minutes for oral argument, although you are not required to use all your time. If appellant wishes to reserve a portion of that time for rebuttal, you are free to do so, but it is up to you to keep track of your own time at the podium. The clock on the podium reflects your total remaining minutes. Please keep in mind that we have read the briefs, studied the record, and discussed the case in conference, so please keep that in mind as you present your case. You may proceed, Mr. Pops.
Good morning, and may it please the court. I'm Andrew Pappas. I represent Melissa Turner and her daughters. I endeavor to reserve 5 minutes for rebuttal. I'm going to begin with the main appeal and then proceed to the cross appeal unless the court would prefer otherwise.
That's fine, thank you.
Your Honors, the main issue on the main appeal is whether the Cuperts could hold assets, and if so, the court must reverse. And more specifically, whether a reasonable jury could conclude that the Cuperts hold assets. The reason for that is simple. If the Cuperts still hold assets, then Brad, as trustee, still owes duties. And so Melissa's claims against him for an accounting, for breach of fiduciary duty, and so on, survive. I think the illustration in our brief captures the issue well. Imagine you have a trust that has a corpus of $1 million and explicit instructions that the trustee has to distribute those assets on a date certain, no ifs, ands, or buts. And then the trustee is asleep at the switch, 5 years passed, and...
But counsel, can we talk about the fact that the res of the trust was actually, there were documents to transfer it prior to the expiration of that trust? Both of the trusts?
Certainly, Your Honor. So there are two kinds of assets, at least, that we think could be in the trusts. One is legal title to the properties, and there's no dispute whatsoever that legal title to the New York properties remains in the Cuperts as of this day. And then there's the question of the mortgages. And I think that's what Your Honor is talking about. And there are a number of documents that are relevant here. There were attempts to assign the mortgages. The Superior Court found that those assignments were effective simply upon sending them without the signatures of Melissa Turner, despite the fact that we know under New York law that signatures are required, that it's evidence of the party's intent when there are blank signature lines, that those signature lines be filled out in order for the documents to be effective. We know that acceptance is required under New York law, and the way that Melissa Turner could accept the assignments was by signing on those lines. And we know that the Superior Court resolved these factual disputes, despite basically acknowledging that they existed, did so improperly because this was on summary judgment, and on summary judgment, all inferences need to be drawn in favor of the non-moving party, which was Melissa Turner as concerned Brad Turner's motion for summary judgment. And we know that the Superior Court committed a spate of legal errors in the process, committed those legal errors and then compounded them by making these improper resolutions of factual questions.
So, counsel, can you explain to me, we have a deadline, so let's take the properties and the assignments out of this. We have a trust that expired on a date certain. What happens from there? It expires. It no longer exists. Can you explain to me your position as to how things happen after that? Because your position is that these things are still in the trust. Is that my understanding?
That's correct, Your Honor. The legal title is undoubtedly still in the trust. Even Brad doesn't dispute that. We believe that the mortgages are still in the trust because there was no effective assignment of those mortgages.
But if there's a deadline and the trust expires on the deadline, how do they still reside within the trust such that any beneficiary of the trust has any interest in them?
So first of all, Your Honor, we don't believe that there is such a deadline in this case. Undoubtedly, there was a date on which the settler's term was going to end. But that is not a deadline for the expiration or even the termination of the trust. And as we pointed out in our briefs, this word termination has different meanings in this context. It doesn't just simply mean the date on which everything is over. It can mean the date after which the trustee, in this case Brad, still owes duties to the beneficiaries. And again, Your Honor, think about our hypothetical. Imagine you've got a trust and you've got terms that say that the trust has to distribute assets on a certain date. Those assets don't get distributed. They remain in the trust. And so the question is, can the trustee simply take them, steal them, walk away with them, and then the beneficiary is left with no legal recourse? Of course not. The law does not sanction that result. We've quoted cases from New York, the restatement, and so on.
But then that would, I mean, that doesn't preclude some kind of like conversion claim or something like that, which would be divorced from a breach of fiduciary duty or a breach of the trust documents.
And in this
or
instance,
like that.
Melissa asserted a conversion claim. So you're right, Your Honor. Even if the court were to conclude that somehow these trusts terminated and that they needed to distribute assets and so on, Melissa's conversion claim survives if a reasonable jury could conclude that the trusts still hold assets. And again, there's no dispute that the trusts still hold at least some assets. They still hold legal title. We know that's important as a legal matter. We know it's important as a practical matter to Brad because during the pendency of this appeal, he went back to the Superior Court and said, I need you to order Melissa to resign as co-trustee of these trusts that I'm claiming terminated in order to effectuate the transfer of legal title out of those trusts. Well, how does that work? It's because Brad himself is the other co-trustee of these trusts that still exist and still hold property. So Brad himself acknowledges that these trusts hold property.
So they're open-ended trusts in terms of the trust's lives?
Well, Your Honor, the trusts do not set a date certain by which they must terminate. They do set an end for the settler's term, but not a date by which they must terminate. And regardless, the trusts, if they retain assets, the court has to reverse because the predicate of the summary judgment ruling by the Superior Court was that the trusts terminated automatically distributed assets because they had to, and so they did. Well, that doesn't work either, Your Honor, just as a matter of common sense. Imagine you've got a hotel that has a checkout time of 11 o'clock. A hotel operator, the person at the front desk can't say, well, it's now 11:01, the room must be vacant, we're setting up the next guests. Just because the checkout time has come and gone doesn't mean the room is vacant. And likewise here, the Superior Court erred by concluding that just because there was a distribution, it saw a distribution date, then the distribution must have occurred on that date. And again, what matters here, what the court ought to focus on in determining whether to reverse the Superior Court is this fundamental question about whether a reasonable jury could conclude that the trust still retains assets. I mentioned already the assignment.
Is that a factual question or a legal question?
It is a quintessential factual question, Judge Howe. It's a factual question that the jury needed to resolve. The Superior Court itself says in its order that that Brad and Terry Turner had sent mixed messages over the years about whether the trusts existed and whether they still held assets, and that the court was providing a definitive answer for the first time to that question. That was not the Superior Court's role. That was a factual question for a jury to resolve. And the jury would have had ample evidence to find that these trusts still retained assets. I mentioned already the ineffective assignment documents.
So the jury would have been instructed on the law on the continued existence of trusts?
Well, the jury would have had to make the factual determination whether these trusts still held assets, and that's precisely.
But by what metric or rubric would they have made that determination?
Well, Your Honor, we would have needed additional facts on that. I mean, remember, the reason why Melissa sued for an accounting is because she doesn't know what was in the trusts, what still is in the trust. We know about the legal title. We can surmise that the mortgages are still there, but we don't know what else is there. And that's what an accounting claim would have helped figure out.
Well, these are residential trusts. They're
They're qualified-
personal residence trusts. So I think you have some notion of what's in there.
Some notion now, Your Honor, although, the Cupert documents themselves refer to all kinds of, discretion vested in the trustees to acquire or dispose of other property, including interests in a business that the settler might have had at the time of his death and so on. And of course, Melissa testified in this case she didn't know about these trusts at all until 2016. And if there were not live factual disputes about what was in the trust, then there would have been no factual disputes for the Superior Court improperly to resolve.
But isn't the first question that the Superior Court had to resolve is whether the trust actually still exists?
Your Honor,
and I think that's what they did.
the Superior Court jumped to the conclusion that the trusts didn't exist based upon, as I said, factual and legal errors. It determined that if they had, well, first of all, that shall distribute meant shall immediately distribute. As we've pointed out in our briefs, that is not supported by New York law. New York law doesn't say that shall means immediately. The Superior Court then said, well, if they had to distribute assets, then they necessarily did distribute assets. But again, there's the underlying factual question about whether they did in fact distribute assets. And if they did not in fact distribute assets, and if the assets remain in the trust, then Melissa's claims against Brad, her tort claims, have to survive. It simply can't be the case.
Isn't the question, isn't it really the factual question whether those assignments actually happened or not? I realize what you're saying, that she didn't sign them, but isn't that really the factual question that needs to be asked before anything is asked?
Well, it's another factual question that a jury needs to resolve, yes, Your Honor, and that it's another reason to reverse the Superior Court's ruling. You know, what was Rod and Terry's intent in including those blank signature lines? The Superior Court said, oh, that's mere surplusage. There is no support in New York law for the notion that that's mere surplusage. New York law is very clear. We've said at the Cadell case, the Longo case, that when you have blank signature lines, that indicates that those signatures have to be there for the documents to be effective. So there was a question there about intent. There was a question about the efficacy of those documents, and that's another question for the jury to resolve. Likewise, with the termination of trust documents, they've said, oh, you know, the beneficiary's consent wasn't needed to terminate the trust. That's also not true. This is an irrevocable trust, meaning that the settler couldn't just terminate it. It was irrevocable. He needed the consent of the beneficiaries. And again, the termination of trust documents themselves have blank signature lines, once again indicating Rod and Terry's intent, or at least evidence that a jury could consider of Rod and Terry's intent, that those documents had to be signed in order to be effective. And even then, the termination of trust documents themselves say that it terminates upon the distribution of the entire corpus of the trust, which takes us back to the original question.
But if those assignments weren't on those documents, couldn't Rod and Terry transfer all of the stuff out of the trust before the end of the settler's date?
I'm sorry.
My understanding is that once the settler's date happened, that automatically transferred to Brad and I'm sorry.
Your Honor, that was the erroneous conclusion that the Superior Court reached. But that is a fact question that the jury needed to resolve, and it's a fact question that gets complicated by these legal errors the Superior Court made about the effectiveness of those assignment documents that we submit under New York law and otherwise were ineffective without the signatures of Melissa, and for that matter, Brad. Brad doesn't claim he signed the assignment documents or that he signed the termination of trust documents. The Superior Court wrongfully concluded and overlooked this fundamental question about whether the trust, in fact, still retains assets. And again, this is the fundamental question, because if it does, if the Cuperts still retain assets, then the trustee still owes duties to the beneficiaries. The law can't sanction...
But what happens if they don't? What happens if there is no property in the trusts anymore? Then where are we?
Well, Your Honor, I think still that's a factual question that the jury would need to resolve, and question about like when it got distributed, and so on. But the Superior Court reached this conclusion that things got distributed automatically in 2006 because that's when the settler's term ended. And again, that compounds factual and legal errors to reach an erroneous result. The Superior Court's ruling is defective in multiple different ways. And these are all questions for a jury to resolve. The jury has to determine, do the trusts still retain assets? I mean, imagine the opposite result, Your Honor. Imagine you have a trust that has assets. The date to distribute has come and gone. Does the trustee really get to just walk away with the assets and the beneficiary has no recourse? That cannot be the law, and it isn't the law. It's not the law in New York. It's not the law of the restatement. And it makes absolutely no sense. There's no reason why the law would sanction that result, and the court shouldn't sanction that result here. Again, the Superior Court's ruling has to be reversed if this court determines that there is a factual question that a reasonable jury could decide to find that the Cuperts still hold assets. We know they hold legal title to the New York properties. And then there are factual questions about whether they still hold the mortgages on which Brad took mortgage interest for years, including during the pendency of this case. I'd like to reserve 5 minutes for rebuttal.
Thank you. Counsel?
Good morning, and may it please the court. I'm Peter Swan, and I represent appellee and cross appellants Brad and Elizine Turner in this matter. Your Honors, there are many ways to characterize the multitude of claims on this record, and you've just been discussing one of them. But I'd like to begin with a very fundamental principle, which is that this court must affirm a judgment if it was correct on any ground. And here, all but two components of the judgment in this case can be affirmed on at least one ground. Now, there are more theories than we can possibly discuss in the time allotted, but just three are needed to affirm the judgment on all the claims that Melissa lost. And these eliminate the need to address the issues concerning the Cuperts that the court has been discussing in my colleague's argument. Those are the bankruptcy settlement, the offset, and the illegality defense. And before I address those, I'd like to just address a few points that Mr. Pappas made so that we don't inadvertently concede them. Number one, the Cuperts terminated by their terms, and the language is contained at IR 258. They provide, they shall terminate upon the expiration of 10 years from the date of this trust agreement. That's number one.
Counsel, if the trust holds property at the time that it ends, so it terminates, what happens to the property?
Well, it becomes an interesting administration problem, Your Honor, because you wind up with a trust that may not have a trustee. And that is the case here. Mr. Pappas assumed that Mr. Turner was the trustee, but he never accepted that role. Anybody could name me a trustee, and I'm suddenly liable for all of the duties that trustees have. But if I don't accept that role, I am not the trustee, and there is no evidence on this record that he ever became the trustee and accepted the role. I will fast forward a little bit just to further answer your question and say that if anybody owed any duties when the trusts terminated, it was the trusts owing a duty to Rod to convey legal title to the properties. But that's an administrative matter that doesn't really go to the dispute between Brad and Melissa. The Sankel case makes very clear that acceptance of the role of trustee is critical, and Brad never became the trustee of these terminated trusts. It is true, Your Honor, that there are all sorts of interesting questions under New York law about how you administer these trusts, but we don't need to reach it because at its core, this case is really about two clusters of claims and four assets. We've got the two New York properties and the mortgages associated with them. They're in a cluster that we've been calling the Cupert claims, and those are subject to the bankruptcy settlement, and a fractional partnership interest in a house in Mexico that is subject to a different set of defenses. That would be the offset and the illegality. So it merits note. I know the court is familiar with the record, but the record is so dense that I just want to give a brief chronology of the reasons that I say these issues predominate all on the side of affirming the portions of the judgment that should be affirmed. After the Cuperts were established, as the court is well aware, Melissa and her ex-husband caused very serious harm to the family fortune. Judge Kessler wrote, I think, a 102-paragraph opinion on the issue. And right before Dawson versus Withacombe was tried, Melissa filed bankruptcy the first time, leaving Rod and Terry holding the bag. But it appears that Rod and Terry were exceptionally fair-minded people because they were precise in their approach to the investments they made with Melissa, but they were not punitive in that. The settlement in 2000 that gave rise to the 2000 note represented exactly 1/2 of the investment funds that were stolen not only from Rod and Terry, but actually from the entire family fortune that could have been available for Brad, Melissa, and their children. Melissa entered into that note and later did a 2001 security agreement, later did a 2006 reaffirmation agreement in which she disclaimed all defenses to the note, but she never paid the Rod and Terry back for the harm she caused. The situation only spun out of control when she failed to honor that commitment because Rod and Terry had, as the court is aware, made provisions for Melissa still to receive her partnership interest and half of the value of the New York properties if she honored her commitment in the 2000 settlement agreement. She did not. Melissa was disinherited in the wills, again, not out of punitive, but because she had received her inheritance.
Mr. Swan, were the wills part of the record? I don't remember seeing them, but...
Well, yes, there is reference in the record to the manner in which the estate plans as a whole, I used wills as a shorthand and I apologize, but the estate plans as a whole were eliminated or amended to eliminate Melissa's participation in parts of it. But Rod and Terry did not intend to completely eliminate Melissa's interest in these assets unless she failed to pay, and that she did.
And what in the record actually says that for us?
Says
that if she didn't pay, that they were disinheriting her, basically.
Well,
what can you point us to?
We certainly have material in the record relating to the estate plans, and I'd be happy to supplement that. But what I would tell you, Your Honor, is that in the record we have evidence of intent in the form of the offset agreement that Rod signed and Melissa never signed. Okay. We have the fact that Rod and Terry left Melissa as a beneficiary, left her with the opportunity to retrieve her leaned up partnership interest, but then things changed, because if we fast forward to 2010, Melissa is now in bankruptcy where she gets denied a discharge, but the trustee settles the case. And this, I think, is really the crux of the Cupert issues. When the trustee settled the case, that was 2010. By their terms, the trusts lost their spendthrift character in 2006. Any claims that Melissa had to the value of the New York properties, be it the properties themselves, the mortgages, whether they were effectively assigned or not, and I'm happy to address whether they were, but it almost doesn't matter because any of those claims to that value were claims of the bankruptcy estate, and they were settled. Melissa does not get the benefit of retrieving those assets from the bankruptcy estate, especially after she was denied a discharge.
Unless they were subject to the spendthrift provision.
True,
of
and
the
had the
trust. So let's talk, because that was the bulk of Mr. Pappas's presentation, is that the trust still exists, and therefore the spendthrift provision would still apply to them. So could you address that?
Happily, Your Honor. I'll begin with a repetition of the fact that the trust's terminated by their terms, but then let me add to that an underscoring of the citation to Maleta versus Bachowski in the briefs, which makes very clear that it is the intent of the settlor that governs. And do we have evidence of the intent of the settlor in the record? We absolutely do. Because Rod signed documents to terminate the trust. And Rod took the assets from the trust out, as the tax regulations required, sold them to himself, gave the mortgages back, and those mortgages he then assigned to Brad and Melissa. Now we can argue about whether the assignment was effective or whether the value lies in the trust, but to Melissa it shouldn't matter. Value is value. The assignments were effective under the McIntosh case that we cited, and that was decided in 1931 in New York, and it's never been even distinguished, much less overruled. All of the authorities in the briefing that you will see on the necessity for an acceptance of the assignment in my colleagues' briefs come from treatises. The case law in New York is clear that the acceptance is not required because there is no delegation of duty here. And that returns us to the trust, right? Anytime you are being given a duty, you must accept it. But to be given a benefit, you don't need to accept it. Right down the street, we have an office that handles unclaimed property. And who knows, we may all be millionaires with property we don't even know about that was assigned to us, but an acceptance is not required. Only showing up with your ID is required to collect it. And here, if the claims hadn't been compromised, it would be an interesting question about where those mortgages lie, what the duty is to convey legal title. But the settlement trumps it all. When the settlement killed these claims, it really doesn't matter how we analyze them in detail or what perspective we take on them, because we know for a fact that they were terminated by virtue of the settlement. The only things that were not terminated by virtue of the settlement were the claim on the 2000 note and the in rem claims relating to the partnership, both of which now belong to Brad. So any interest in those mortgages was an asset of the bankruptcy estate, and the trustee permanently removed Melissa's ability to sue on that interest. I would point out that that wasn't a freebie. The Turner parties in the settlement gave up more than $10 million of claims against the bankruptcy estate and even paid in $38,000 to secure this agreement. Brad and Terry did not receive a windfall. They bargained for this settlement. Or at least Terry bargained for this settlement because it occurred after Rod's death. It's absolutely crucial to the functioning of the law that we honor these settlement agreements. And I cannot stress strongly enough that if the settlement agreement is held to be meaningless, that throws the entire case into chaos. Now, if I may turn for a moment to the partnership interest, because that hasn't been discussed yet. In the 2000 settlement and the 2001 security agreement placed a lien on Melissa's partnership interest. So for 23 years or 24 years, Melissa has had negative equity in her partnership interest. It's been leaned up well beyond its value by virtue not only of the 2000 note, but by virtue of other creditors' claims. And in 2012, Terry wanted to foreclose on that interest. Melissa's idea was once foreclosed, the security interest would disappear, and then that partnership interest could be placed in trust for her and her children. Now, it is fine to use various devices like trusts and other estate planning mechanisms to shield your assets from creditors, but only if they're future creditors. It is not legal to use those devices to shield your assets from creditors who have secured claims on the assets you're trying to shield. So the scheme that Melissa wanted Brad to perpetrate was one in which she would extinguish all the creditors' interest in this partnership, and out of a foreclosure she would actually receive value, not give it to the creditors. That is against public policy. That is unlawful. And so it is understandable why the Superior Court vacated that portion of the jury verdict that gave Melissa $600,000 for Brad's alleged failure to participate in this scheme. The scheme was unenforceable from the get-go, and the trial court quite rightly recognized that. The other thing that the trial court quite rightly recognized, and this is after a bench trial, and the trial court cited its own equitable discretion in reaching this conclusion. The other thing is that there's an offset here, that to the extent Melissa owes money, she cannot collect it without accounting for the money that she owes. Okay, both of those are fatal to the partnership claims. Where the trial court, and I've got 5 minutes left, so I want to turn for a moment to the cross appeal. Where the trial court erred was by submitting the note claim to the jury. And a little history, I think, is important. Brad never sued Melissa on the note. Brad sought to use the note as an offset. It was Melissa's counsel at trial who demanded that claim be couched in the form of a counterclaim, which the trial court allowed. Brad obviously followed the trial court's direction. But this was not an action to go after Melissa. Brad is the defendant here. And there is no evidence, none, to suggest that the note is not a black and white obligation. It is not general damages where the jury can pick a number, right? The court will recall that at trial the jury asked, can we fine for Brad on the note but give him nothing? And the court said, read your instructions. Then the jury came back for Melissa. I understand that the jury may not have wanted to subject Melissa or re-subject her to the debt that she incurred 24 years ago and then reaffirmed, but that's the result the law requires. There is no basis for the jury's verdict holding that Melissa prevails on the note, and that portion of the judgment should be reversed and remanded with instructions to enter judgment for Brad. Secondly, we get to the attorney's fee issue, which is quite puzzling to me. The court awarded Brad costs. That's what you do for a prevailing party. Jury costs, court costs under 12-332. But it awarded Melissa attorney's fees. And that's an impossibility. Not only does the court have to find that Melissa is the prevailing party, but that finding has to have something underlying it. And I think I certainly am aware of and respect the discretion of the trial courts to determine prevailing party. But when you sue for $5 trillion, which they did in this case, if the United States had paid this debt that they sued on, there would be a global currency collapse. When you sue for $5 trillion and walk away with nothing, it stretches the definition of prevailing party too far. And I think that is one of the rare cases in which you truly have an abuse of discretion. Couple that with the inconsistency between the cost order and the fee order, and I think you have an abuse of discretion and grounds to reverse and remand the fee award.
So, Mr. Swan,
Yes.
one question on the note issue. Isn't that waived?
The note issue.
Didn't you waive it? Didn't Brad waive it?
I'm not sure I understand which issue you're talking about.
The note issue that Melissa prevailed on at the Superior Court.
I don't believe it's waived at all, and I'm puzzled as to why.
Well, I mean, I think the question is that I'm just looking at my notes here, and again, I'd have to go back and really look at it, but my understanding is that the lien on the partnership interest was invalid, or the foreclosure was ineffective. If that's what you're arguing, then you shouldn't be allowed to keep the partnership interest as obtained.
Oh, I see. We're arguing I think we're talking about two different claims, Your Honor.
Okay.
So the foreclosure was not ineffective. The foreclosure was effective if carried out according to public policy, which is effectively the result that the court reached. We're not appealing that. What we are appealing is the notion that the note itself carries with it no liability. There was no basis for the jury to find that, none at all. And so that's the cross appeal. We're not appealing.
Thank you for that clarification.
Yeah. So when we if I can in my last few seconds just say that I can readily accept that the court has broad discretion on the attorney's fee award, and I'm not asking the court to determine it here today, but I do believe that the appropriate result in this case would be to affirm the judgment in all respects, except that the case should be remanded for entry in favor of Brad on the note according to its face value, and for redetermination of attorney's fees with Brad as the prevailing party. Now, what the court does with the amount of attorney's fees, of course, is up to the court, and I'm not going to argue minutia. But there's simply no way that you can lose 77 claims for $5 trillion entirely and say you won.
Thank you.
Thank you, Your Honor.
Mr. Pappas, let's start with the claim for $5 trillion.
Sure, Your Honor. There was a claim on a note that had a provision for 12% interest compounded monthly. That's how they got to the number 5 trillion. But even then, Melissa's submissions gave a range of possible damages, acknowledging that $5 trillion was very high. So they've made a lot of that, Your Honor. It's really of no moment. I'll begin, I guess, where Mr. Swan ended, try to work my way backwards on attorney's fees. The idea that there's some impossibility that fees were awarded to Melissa. Melissa was awarded fees under the mandatory fee shifting provision of the note, a claim on which she prevailed.
And your affidavit covered more than just the note, correct?
The affidavit did, Your Honor. That's correct. The affidavit covers a bunch of things. It allocates fees among different claims. The Superior Court was well within its discretion in concluding, consistent with the affidavit, that 25% of the fees incurred $233,000 or something like that.
But if she prevails on one particular claim, and the affidavit includes more than just one particular claim, how is that supportable?
They've raised the question about this partnership dissolution claim. Brad's own submissions to the trial court said that the fees incurred on that claim were negligible. And so the trial court could conclude within its discretion that the allocation, the rough justice that the law allows the trial court to make, was well supported. With respect to the note claim, Your Honor, Judge Foster, you're right that this was waived. It was waived. The court lacks jurisdiction over it because Brad never filed the appropriate post-trial motions to preserve the issue. That's why it's waived. There is no judgment from which Brad appeals that can give him judgment as a matter of law, which is the relief he seeks on appeal. He filed a Rule 50A motion that didn't account for all of Melissa's defenses. He never filed a Rule 50B motion. It is axiomatic that he needed to do so to preserve.
I agree with you about sufficiency of the evidence about whether or not it prevailed or did not prevail, but what about the question of law about whether or not there was nothing due under the note? I think that was what Mr. Swan was arguing.
Well, it doesn't begin to account for the defenses that Melissa asserted that were tried to the jury, defenses on modification, condition, material breach. Brad has to run the table. He has to win everything to eliminate the verdict in Melissa's favor, because a general jury verdict can be affirmed on any basis that the evidence supports. And here the evidence, as we've laid out in our submissions, is ample to support the jury's verdict for Melissa on the note claim, which is also the basis for the fee award.
So your argument is that those defenses zeroed out the actual liability that?
Your Honor, our argument is that when you have a jury verdict, a general jury verdict, you don't know exactly what was in the jury's mind, but we know that they found for Melissa and against Brad, and as long as the evidence supports any theory that could support it, that's sufficient.
So they erased millions of dollars of liability.
As often happens in contract cases, Your Honor, the plaintiff asserts a claim, the defendant asserts defenses, it goes to a jury. And in this instance, the jury found for Melissa, and there's absolutely no reason why the court should disturb that verdict. Turning to illegality, the defense on which the court took away the promissory estoppel verdict that the jury rendered in Melissa's favor. Your Honor, what eliminated the claims of junior creditors was the foreclosure that Brad engineered. It was not any promise to convey to a spendthrift trust for the benefit of Melissa, and it was the foreclosure itself. And there's no dispute that the foreclosure occurred, that the foreclosure was engineered by Brad, not by Melissa. And in fact, the jury found that Brad had made a promise, and they were going to hold him to that promise. It was a superior court that went the other way. On the bankruptcy settlement, Your Honor is right. As long as there are assets in the trusts and those spendthrift provisions are intact, when the bankruptcy settlements has nothing to do with these claims or the assets in the trusts. And then finally, to go back to the trusts themselves, Mr. Swan said that the trusts say that they shall terminate. That's not what they say. App 226, provision 3B of the trust says, and 3C refers to the settler's term shall terminate. That's different from whether the trust terminates. And again, the essential question here is not how, because
in what way specifically?
Sure.
So give me a citation.
Sure. Well, we've cited, for instance, Restatement 3rd, Section 89. We've cited the Townsend case from New York that says that even after the point of, say, termination, again, a term that has a loose meaning in the law, the trustee still owes duties if the trusts still hold assets. And the trusts themselves contemplate that the disposition of assets can occur after the end of the settler's term. I would refer, Your Honor.
So you have a trust devoid of a settler.
Well, you have the trust with trustees, and that's really the point.
Who didn't accept?
Your Honor, there was nothing in Article 7 that said that that was how Brad had to become trustee. And again, I'll point, Your Honor, to the fact that Brad went back to the Superior Court and said Melissa has to resign as co-trustee so that Brad, as co-trustee, can transfer assets out of the trusts today.
So a person can be involuntarily a trustee?
A trustee can accept trusteeship through his affirmative acts. Brad admitted in a deposition that he was the trustee. He acted for years as the trustee. He said it was as the trustee that he made the decision to eliminate Melissa's interest in the mortgages. It was only after Brad realized that that was going to subject him to legal liability for the various torts that he had committed that he decided to change tacks and say, oh, actually, I never became trustee, and the trust's terminated, and they have no assets. Up to that point, Brad had acted entirely to the contrary, Your Honor. The court should affirm on the cross appeal. It should reverse on the main appeal. It should send this back on the main appeal to a jury to resolve in the first instance. And it should reverse on the illegality verdict. Thank you, Your Honors.
Thank you, counsel, for your presentations. We have your briefs. We appreciate your work, and we will issue a decision in due course. Court's adjourned.